the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Good afternoon, everyone. I apologize for being a little late. We had some meetings on the energy bill, so we're still in negotiation, so thank you for being patient. The prayer will be offered by the delegate from Anne Arundel County.
Thank you, Madam Speaker. You came in here so fast, like a bolt of lightning.
I did, because I don't like to be late.
That's
so
okay. That's okay.
thank you.
We are on God's time, Madam Speaker.
Thank you.
Gracious God, on this glorious Friday, as this afternoon unfolds in the midst of a demanding and decisive week, we pause to seek your wisdom and guidance. In the busyness, the deadlines, and the weight of responsibility, grant clarity of mind and steadiness of purpose to all who serve. Give these great leaders discernment as they consider each bill, patience in their conversation, and integrity in their decisions. Help them to listen well, to act justly, and to seek the good of all people, especially those whose voices are often unheard. In moments of pressure or disagreement, bring calm. In times of fatigue, renew their strength. Let cooperation rise above division, and let truth guide every word and action. May our work this afternoon reflect a commitment to fairness, compassion, and the common good. And when this session ends, may we know that we have served with honor and purpose. Happy Easter, Madam Speaker. Happy Easter, colleagues. And
Thank
we
you.
all say,
Amen.
Amen.
Thank you. Current call.
Madam Speaker.
Madam Speaker, my button's not working.
Yes,
My button's not working.
his button is
It's
not
working
working.
now.
The gentleman from Eastern Shore.
It is not.
Can we have a seat and give me a second, a few minutes to tell you something? So we're going to get started. We have a lot of work at the desk tonight. Tomorrow we will not come in. Okay? But I want us to be judicious about the floor work, okay? And we'll be in on Monday early. And I just want to thank you ahead of time for the work we're going to do for the next few hours. Again, thank you. Will the clerk please take the call? There being 113 members present, the House is in session. Petitions, memorials, and other papers. Which one is this one? Okay, I will. Thank you. I'm going to call on you in a minute. We have special order calendar, House Bill 774. And the clerk, will you be so kind and read the bill?
House Bill 774, landlord and tenant residential leases and holdover tenancies, local good cause termination, good cause eviction. Favor report amended.
I'm recognizing the delegate from the Eastern Shore, who's the maker of the special order.
Thank you, Madam Speaker.
You're welcome.
I have an amendment at the desk, 703-728/1.
Amendment number 1.
So much be considered the reading of the amendment.
So order.
So this amendment speaks to, I'm going to ask the floor leader to rise for a couple back and forth questions.
Floor leader.
So the amendment is seeking to make sure that if there is a action or a claim that the tenant makes here, is that they continue during the legal proceeding to pay any of the rent, late fees, meet all the obligations under the lease during that time frame. So I'd ask the floor leader to rise for just a minute. What I'm trying to do under this amendment, and I had a few, this is the one that I believe is most laudable for the sake of our bill here debate today, is that when this happens, it's going to happen at the end of the lease. Somebody's going to say, we're not going to renew your lease. And the tenant's going to say, well, no, you don't have good cause. This is what the law says. And so the judicial component of that is it's going to take time. I would imagine months between when the tenant says, hey, we've got a problem. I don't like the reason why you are terminating the lease and then trying to figure out in court whether or not there was actually good cause. So do I have it correct in a proceeding that, number one, it's going to take time, and that there's going to be this period of time where the lease has expired, okay, but yet the tenant's still going to be living in the unit while this is happening?
Mr. Speaker.
Floor leader.
Thank you, Mr. Speaker, and thank you, colleague. So I think what you want to understand, and I will be asking the body to resist your amendment, and primarily because it's redundant. I think that your concerns are valid ones, that if you have a tenant holding over situation while a process is happening where an eviction is occurring right now, so let's assume that the bill doesn't pass. Right now, if you have a tenant holding over situation and a landlord who is beginning a process to get that tenant removed, the tenant, while they're still there, is still expected to pay all of the rent, all of the fees, all of the stuff that your amendment requires. Should this bill pass, and I want to just remind the body that this is enabling legislation, so this would require then a local county to adopt this legislation, but should it pass, it'll be overlaid on top of all of the current tenant holding over, both the fees, the requirements, but also the time frames. So nothing would be different. The only thing that would be different compared to what happens now is that instead of a landlord going to court and saying, I asked them to leave and they didn't, the landlord would have to go to court and say, I asked them to leave because they were disrupting the property and they didn't, and then the tenant would come in and say, I wasn't, or I was, or whatever they're going to say.
So the concern I have is that for many of these cases where landlords are saying we're not going to renew the lease, it's going to come down to late payment. And so when a tenant is holding over and they're not paying their rent to begin with, and then they're actually going to go through the proceeding, there's really no action that a landlord's going to be able to take between that moment in time where the lease expires and when ultimately a court decides what's going to happen. And my issue here is that we're not talking about maybe 1 month's worth of rent or 2 months. It could take a few months for the courts to get from the point where the tenant says, hey, we're going to go to court, we're going to try to resolve this dispute, and when the courts actually say, okay, landlord, you had good cause or you didn't, I believe that it's important in this bill to at least speak to the idea that while we have a lease that's expired, under the bill, under the law, if this passes, that we are saying in an affirmative way that the tenant is still obligated to pay rent on a month-to-month basis, which is what the bill amendment is trying to say. Moving forward, they still have those obligations. Ultimately, what could happen here, and why I'm interested in this amendment, is that you might have somebody that owes 2 months' worth of rent, and then the court takes 3 months to go through this adjudication. Now you're talking about 5 months' worth of rent. Now you're forcing a landlord to get into a money judgment situation because, look, most landlords don't go for money judgments. They go for possession of the property, but not if you owe me $5,000 or $6,000 or $7,000. And so the amendment is really just making sure that the tenant knows, okay, you're doing this, but while you're living in this house in a holdover setting, you still have to pay the rent. You're still obligated under the lease, and that the landlord can still come after you for non-payment of rent. So, Mr. Speaker, I'm sure the floor leader can respond to what I'm saying, but it's the ultimate point I'm trying to make here is that the bill has some unworkable components to it. This one I've concluded is one of the most difficult ones, is the courts don't move fast enough when it comes to disputes like this, and that these monies that are going to be due and payable after the lease is expired, okay, after the lease is expired, we have to make sure the legislature holds the landlord harmless. That's all this amendment does, and I'd ask the body to support the amendment.
Floor leader.
Mr. Speaker, thank you. I just want to urge the body to resist this amendment for two reasons. One is it is redundant. It is already law, and this bill really goes in parallel to the current tenant holding over law, which addresses this and many other things. And in fact, to the gentleman's concern, if we pull this section out of the tenant holding over law and put it into this bill, and we don't pull other sections, it could actually send the wrong message to the judiciary considering these cases, that we only intend to consider this section of tenant holding over. So because it's redundant, because it's already there, in all of the other sections that would be still in law should this bill pass, and should a local county decide to enable it, I urge the body to resist the amendment.
Delegate from the Eastern Shore.
I'd ask the body to move the amendment.
Question before the House is the adoption of the amendment. All in favor signify by saying aye. All opposed, no. The noes have it. The amendment fails. There are enough standing for a roll call. The clerk will call the roll.
Mr. Speaker?
Has everyone recorded their vote? Oh, yeah. Has everyone recorded their vote? Does anyone like to change their vote? The clerk will take the call.
You got it?
With 79 votes in the negative, the amendment fails. Are there further amendments to
Mr.
the
Speaker?
bill or to its title? The delegate from Carroll County.
Thank you, Mr. Speaker. I have an amendment at the desk. It's amendment number 913524-1.
Amendment number 1.
Move so much be considered the reading of the amendment.
So ordered.
Thank you, Mr. Speaker. So as we all know, the bill establishes roughly a dozen reasons that constitute a good cause. My amendment adds an additional reason to that list. The amendment adds that a tenant's occupancy is conditioned on employment on the property, and the employment relationship is terminated. So it's obviously not uncommon for landlords to employ a property manager, a resident manager, or a maintenance worker. And oftentimes, that employment comes with employment-based housing, which is often part of the total compensation package. So I think it's more than reasonable to just say that if the job comes to an end, there's no reason that the landlord should be expected to automatically renew their lease if that individual has a desire to stay. So without this amendment, my fear is that former employees would be able to remain in units meant for active staff or new staff, or quite frankly, the staff that's probably replacing them, even after the employment comes to an end. I think it's also important to note that there's several cities across our country that have good or just cause eviction ordinances. Places such as St. Paul and Seattle, in their ordinance, they also have this place listed, or they have this exact same amendment in there. So with that, Mr. Speaker, I'd like to move the amendment.
Floor leader.
Mr. Speaker, we accept this as a friendly amendment.
All right, the question before the House is the adoption of the amendment. All in favor will signify by saying aye. Any opposed, no. The ayes have it. The amendment is adopted. There are further amendments to the bill or to its title. The gentleman from the Eastern Shore.
Thank you, Mr. Speaker. I have an amendment at the desk, 913120/1.
Amendment number 1.
So much be considered the reading of the amendment.
So ordered.
Ladies and gentlemen, this thing in the bill, we don't really address short-term rentals like VRBOs and that type of event, and this bill just wants to ensure that they're exempted from the bill. This amendment, I'm sorry. So move the amendment.
Floor leader.
This is 913, thank you, Mr. Speaker, 913-120. Mr. Speaker, we accept this as a friendly amendment.
All right.
Do you mind if I stand here for a minute or so? Thank you.
I'm happy to find something else to discuss with you if you'd
The
like.
question before the House is the adoption of the amendment. All in favor shall signify by saying aye. Opposed, no. The ayes have it. The amendment is adopted. Are there any other amendments to the bill or to its title? The delegate from Carroll County.
Thank you, Mr. Speaker. I have an amendment at the desk, amendment number 283420-1.
Amendment number 1.
Move so much be the reading of this amendment.
So ordered.
So this amendment, if you look at page 6 of the original bill, down at the very bottom, it says a tenant habitually failing to pay rent when due if the tenant has been notified by the landlord in writing that it is more than 10 days late at least 4 times in a 12-month period. This amendment will simply change that to 3 times. In speaking with landlords, most of which are small, with no more than 10 units, they have reported the following. Once the 10 days have happened, a notice has to be sent. Once that notice has been sent, certified mail and electronically, then the landlord must go physically to court. A date is requested, and it typically takes 2 to 3 weeks to get the court date assigned. If found in favor to evict or remove, it takes another approximately 3 months to get a date to remove. If we're keeping track, we're now at about 4 months. This timeline is not taking into account any delays or appeals, which typically happens and is typically done with free legal counsel by the tenant. 4+ months as a landlord without income to do what cannot be delayed: mortgage payments, maintenance of property, utility payments depending on how that lease is set up. If a payment is sent and accepted, even if partial, the entire process starts all over again. If the property owner does get a date for the sheriff to remove, this can also be delayed based on weather. Below 32 degrees, if there's rain or snow, heat advisories. We all live in the same state. We know that happens quite a bit throughout the year. I think this is reasonable to reduce it just from 4 months to 3. We have a report from the comptroller that we have a shortage of rental units available in the state of Maryland. We need to really keep in mind of what we are doing to make it harder for landlords to continue to provide this to our folks and our citizens in the state of Maryland. So I ask that you consider this amendment and vote favorable. Thank you, Mr. Speaker.
Floor leader.
Thank you, Mr. Speaker. And thank you, colleague, for the amendment. I think I'm going to try to be brief in explaining why we don't need the amendment, but I do feel like I need to back up and explain what the bill does, because I think the details of what we're discussing when we're asking our colleagues to resist the amendments, it's important to understand what the bill does. First of all, this is a enabling legislation. So if we pass this law, each individual county would have to choose to enable this locally. So nothing will happen in your county unless your county also goes through a process that chooses to move this forward. So that's the first thing. The second thing is that what this bill is about creating stability in our communities, in our schools, in the communities where we have a lot of turnover, where families are moving on a regular basis, sometimes for no particularly good reason. It creates chaos in children's lives. It creates challenges in communities. Communities are less safe. Schools are less successful. And so the goal of this bill is to make sure that if a family is going to be moved out of their home, there's got to be a good reason. The implications for the broader community and the implications for the children's education is significant. And so then the question becomes, what are the good reasons? What are the good reasons to have a family move out of their home when their lease is up? To have a family every year have to go from one place to the next when the lease is up. And that's what this list is. So this list is what are the good reasons for any county that chooses to implement good cause eviction. And there are many good reasons. Of course, if someone is destructive in the community, if they're doing illegal things, if they're making it hard for their neighbors to live there, if they're substantially violating lease, those are all good reasons for a tenant to be asked to leave. But one of the ones, and this is the one that this amendment addresses, addresses this question about the late payment of rent. And what the delegate described is the process to evict someone for late payment of rent. And it is a process that, in fact, after 10 days, the warning, and then after the warning, the filing in court, and then there's a court case, and then the tenant has a certain amount of money to pay. That whole process is not touched by this bill. This bill, as I said in the earlier amendment, does not change the broader landlord-tenant law that we have in the state. What this section of the bill does is it says if a tenant is more than 10 days late with their rent 4 times in a year, then that is a good cause reason at the end of the 12 months to terminate their lease. What that means is they're 10 days late, they pay on day 11. They're 10 days late, they pay on day 11. They're 10 days late, they pay on day 11. If that happens 5 times, then they can be evicted at the end of their lease. But none of that changes the fact that if they are late and don't pay in the middle of their lease, they can still be evicted. And I think that is what the good delegate was trying to address with this amendment. The balancing act that we have here about what are good causes to end leases, we believe 4 times of 10 days or more is appropriate while not restricting any current ability for a landlord to evict a tenant for not paying rent. So for those reasons, I urge the body to resist this amendment.
Maker of the amendment.
And I appreciate your comments. Couple of comments. So it's enabling now. We've passed quite a bit of legislation this year that we've passed said because something might happen. We've done that several times now. So it's enabling this year. What does that tell us about next year or following years, number one? And you talk about stability. Well, what about the stability for the landowner, the homeowner, that is trying to be a good faith landlord? I'm talking about 1 month difference in this bill. And I just spelled out the time. It can take up to 3 months, sometimes 4 months to go through this process. And let's say you just have a few properties, and let's say that you have mortgages. During that entire time, the entire point is you still have to pay your mortgage. You still have to keep the maintenance up on the property. You may or may not have to pay all of the utilities, all while going through this process, which also includes often free legal counsel that the landlord doesn't receive, just the tenant. And I think that asking for the additional time, the least amount of time for the landlord to have to go through this is fair. I don't think anybody wants to, landlords are in the business of being landlords because they want to make money and they want to provide housing. And again, we say we have $100,000 units that we need in the state of Maryland. We are passing legislation that is sending the message of, why do I want to be a landlord in the state of Maryland when I have to subject myself to so many delays and ways of you're trying to do a good job to provide housing for people, but yet you do have to cover all of these costs. So I think it's a very simple amendment. It's a very small ask, and I hope that you will support me in this very common sense amendment. Thank you.
Floor leader.
Thank you, Mr. Speaker. I just want to clarify again, I think maybe you're talking about something different. You're talking about 4 months versus 3 months. The bill is about 10 days. Late 10 days 4 times. So this bill and your amendment wouldn't change the time frame that it takes to evict someone for failure to pay rent. That's in another section of law. So I think I've explained why it doesn't make sense to change this from 4 times to 3 times, but I just want to make sure folks understand what they're voting on in terms of the number of months, because that's not touched in this bill. And so for those reasons, Mr. Speaker, I urge the body to resist this amendment.
Maker of the amendment.
Thank you, Mr. Speaker. On the bill, page 6 of the original first draft, where this applies, a tenant habitually failing to pay rent when due if the tenant has been notified by the landlord in writing that the rent is more than 10 days late at least 4 times in a 12-month period. That is referenced in the bill. I'm asking for 3 times. That is the very simple, clear request in this amendment, and I ask that you support the amendment. Thank you.
Question before the House is the adoption of the amendment. All in favor signify by saying aye. Opposed, no. The noes have it. There's been a request for a roll call. There's sufficient number having stood. The clerk will call the roll.
Mr. Speaker?
Has everyone recorded their votes? Would anyone like to change their votes? The clerk will take the call. With 79 votes in the negative, the amendment fails. Are there any further amendments to the bill or to its title?
Mr.
Delegate
Speaker.
from Western Maryland.
Thank you. I have an amendment at the desk. It is number 233222/1.
Amendment number 1.
Move so much be considered the reading of the amendment.
Sorted.
Was that a yes? For those that were here in 2021, as you may recall, we had a House Bill 18 titled the Maryland Access to Counsel and Evictions Program, or otherwise known as ACE. It was enacted by the legislature and provides free legal representation to low-income tenants facing eviction. Low-income tenants are defined as those at or below 50% of the state's median income. Representation is provided for failure to pay rent, breach of lease, and tenant holding over cases. What this amendment does is extend eligibility to access that fund to the landlord. House Bill 18 has an incorrect assumption that all landlords are wealthy. While that might be the case in some jurisdictions, it's not necessarily the case in the areas that I represent. This amendment levels the playing field. It's about fairness. It provides access to the fund for landlords who are at or below 50% of the state's median income, the same access that is provided to the tenant. The original ACE program was premised on the assumption that landlords uniformly possess greater financial resources than tenants. That assumption does not hold true across Maryland, particularly in rural, suburban, and mixed-income districts. Many landlords are small-scale property owners, often individuals or families who rely on rental income to cover mortgages, taxes, insurance, and maintenance. Allowing landlords who are at or below the 50% of the state's median income to access the same legal assistance as qualifying tenants simply extends equal treatment to similarly situated parties. The eviction process is a legal proceeding with serious consequences for both sides, and access to counsel should be based on financial need, not presumptions about wealth. I move the amendment.
Floor leader.
Thank you, Mr. Speaker. Thank you for the amendment. I urge the body to resist the amendment, and I just want to highlight that the vast majority of landlords are already represented in court. The vast majority of tenants are not, and that's what led the body a couple of years ago to establish this fund. The body was very deliberative about thinking about how to establish the fund, what the purpose of the fund was, and the purpose of the fund was to represent tenants, low-income, very, very low-income tenants in eviction proceedings. And I would just highlight a couple of things about this. While the vast majority of landlords are represented in court, that doesn't mean that there aren't some who aren't, and that doesn't mean there aren't some who have lower income. This bill only applies to landlords who have 6 or more properties, which makes it even less likely that those would be a low-income landlord. The implications of this amendment really reverses significant legislation that we passed in previous years, and so while for the most part, this is not going to apply to landlords that this bill applies to, and because it has implications well beyond this bill, I urge the body to resist the amendment.
Delegate from Western Maryland, then I'll come.
Thank you, Mr. Speaker. If I could ask the floor leader a couple questions.
To the floor leader.
Sure.
So you made a statement that most of the landlords or majority are represented by counsel. Could you tell the body what percentage that is?
I think it is 90%.
And who pays for that?
The landlords.
Yep. And do you believe that landlords generally pass those costs on to tenants where possible?
Yeah, I mean, it's a business. I mean, I assume it's a business expense. There's a bunch of business expenses that go along with owning and managing property. So yes, it would seem it would be a business expense.
So then I know affordability has been a big discussion this session. How does that help with affordability of rental properties?
I think that this bill is about stability in communities. And we recognize that in order to have stable and safe housing, there are restrictions that we put on the business of providing housing. And so while we appreciate the job and the role of landlords in providing housing, we also put restrictions and guidelines around how they do that. And we recognize as a body that doing that creates business expenses, and there's revenue. And so landlords figure that out.
Okay. Thank you.
Mr. Floor Leader.
Still recognize the delegate from Western Maryland. I see the other people who stood up. Delegate from Western Maryland.
Thank you, Mr. Speaker. I still maintain that in my district, a significant portion of our landlords are mom and pop owners, individuals who might have inherited a home, retirees relying on rental income as fixed retirement plan, and working families who purchase additional properties as long-term investments. So these landlords, you might think they're property rich, but many times they're cash poor, putting their own sweat equity and earnings into these properties. They're not national or multinational corporations that we see in some districts with in-house counsel or deep reserves. They're struggling to meet their daily needs just as everyone else. And I think treating them as such creates a balance or an imbalance in the system where we're favoring one party over another with legal representation, and it's for those reasons I press the amendment.
I see the floor leader, then I'm going to the delegate from Baltimore City, then delegate from Baltimore County. Floor leader.
Thank you, Mr. Speaker. I just want to, the examples that were given, I agree. I think that that does describe some landlords. That generally does not describe landlords with 6 or more properties, which is what this bill would apply to if it is enabled locally. The second is that for the landlords, it is a business expense that is tax deductible. If they have to go to court for a tenant, it's not. And if the gentleman believes that there is a significant amount of landlords who need representation, I think that it is a worthwhile conversation to have separate from this bill, and perhaps it's a bill for a future year.
Delegate from Baltimore City.
Thank you, Mr. Speaker. I've worked on landlord-tenant issues dealing with lead paint and the legal representation issue for decades. There is an imbalance. Landlords don't have to be represented by lawyers in eviction cases. They had the power to get that change made in the law. God forbid if the tenants had tried to get the same authority. That bill would have been vigorously opposed by the landlords, no doubt about it. I've worked with Steve Sachs, former Attorney General of the state of Maryland, on getting legal representation for tenants. They're the people who need the assistance. Thank you.
Delegate from Baltimore County.
Thank you, Mr. Floor Leader, or Speaker. Would the floor leader rise? I just would like clarification.
The floor leader.
Yes.
So you gave a number, some high percentage of landlords that are represented by attorneys. Can you tell me what that is?
Yes, it's this is from folks who represent folks in landlord-tenant court, and it's 90%.
90%
are represented. Yeah, that's
so represented and representing by attorneys are two different
by
things.
attorneys. Yeah.
Okay, that data, I think you're reading wrong. As a person who's been a landlord and gone to rent court and paid people to go to rent court for me, they were not attorneys.
Okay.
That is a company that is just there to file your paperwork. So I find that very misleading for you to say landlords have, quote, attorneys there. That would not make sense from a business standpoint. So I just like you to clarify that these are not attorneys. They may be a representative, which is a company you can hire to go to rent court for you, but they are almost exclusively not attorneys.
Okay, so this piece of data, if what you're saying is accurate, which it may be, because this is information that I'm looking up while we're having this conversation, but in that case, you're still talking about people who understand, or sophisticated and understand the rent court process and understand landlord-tenant law, even if they're not attorneys, in a way that a tenant by themselves wouldn't. So thanks for the chance to clarify that. On the amendment, I would just say...
Well, hold on. So this is a valid point, though, that these are not attorneys, and I disagree with you. Have you ever been to rent court?
I have.
It's mostly just... Why are they late? Here's the paperwork. Why are they late? Here's the paperwork. It is not an attorney or somebody there like that. So acting like landlords have these massive people backing them in rent court is just false. So I urge you to vote for this amendment. Thank you.
The floor leader.
Yeah, I urge the body to resist the amendment. This fund was set up. It's still not, it runs out of money. It's not enough to do what it was set up to do. So before we expand it, I think that would need a whole bunch of other conversations. And this bill is not about that fund. I urge the body to resist the amendment.
Question before the House is the adoption of the amendment. All in favor signify by saying aye. Aye. Opposed, no. The noes have it. The clerk will take the call.
Mr. Speaker?
Has everyone recorded their vote? Would anyone like to change their votes? The clerk will take the call. With 78 votes in the negative, the amendment fails. Are there further amendments to the bill or to its title? The delegate from Western Maryland.
Thank you, Mr. Speaker. I have another amendment at the desk. It is 113420/1.
Amendment number 1.
Move so much be considered the reading of the amendment.
So ordered.
So this amendment covers the same topic as the last one, attorney's fees. It's just a little bit of a different approach. As we all know, attorney's fees can be pretty high these days. So what this amendment states is that if a court finds that a landlord has good cause to terminate a holdover tenancy, that court will also require the tenant to pay the landlord's reasonable attorney's fees. Attorney's fees are routinely awarded to the prevailing party in such cases. Therefore, I move the amendment.
Floor leader.
Thank you, Mr. Speaker. I would urge the body to resist this amendment for two reasons. One is I just want to remind the body that this very specific piece of law would run concurrent with all of landlord-tenant law that already exists. And in current landlord-tenant law, and in all law, in fact, the court has the jurisdiction to determine which party pays which portion of which attorney's fees based on who prevails and whatever other things the court chooses to consider in that process. And so what this amendment would do is it would actually remove the discretion of the court, who currently has the ability to order these attorney fees to be paid in this way or in some other way as they see fit. So for those reasons, I urge the body to resist the amendment.
Mr. Speaker.
Delegate from the Eastern Shore.
Sorry about that. Here's the problem. When you have a case like this, it's going to look like not the non-payment of rent that you can sort of self-help. It's a breach of lease action. It does require an attorney, and not just any attorney. You want a good one that can prove that the landlord had good cause by preponderance of the evidence. So that's not just to show up in court and try to figure this thing out. You have to hire an attorney, do the research, give the attorney the evidence, make sure that they can sit in a court of law and win not only on its merits, but beyond the preponderance of the evidence. I'm not a lawyer. Probably should have let the lawyer just stand up and do your thing. But I can say for my part, when it comes to more sophisticated actions that you take in court, these are not inexpensive. It is timely, and these are the kind of expenses that we should be instructing the judiciary to reimburse those to landlords. With that, I support the maker of the amendment.
Minority Leader.
Thank you, Mr. Speaker. I appreciate the comments of the floor leader, but I think that that's not a correct necessarily assertion of how it works. And here in America, we follow the American rule for attorney's fees. And what that means is that attorney's fees do not shift unless it is provided for in a contract that says if I win, I get the attorney's fees, or if there is a statute that expressly authorizes the prevailing party to appeal to the court or request the court to shift the fees. There's another thing called the English rule, and in the English rule, if you were suing in Great Britain, they do that as a matter of course. If you win, you get your attorney's fees paid by the loser, no matter what, with few exceptions. We don't do that here. And so what this amendment would do is it would actually be in accordance with the fee-shifting provisions of Maryland law that says we're expressly authorizing in a statute that if you don't already have it in your contract, and I'll concede that 90% probably of landlords probably already have a provision in most of their residential leases that says if I have to sue you for eviction or for back rent and I prevail, I also get my attorney's fees. Got to be bluntly honest with you. If you can't pay me the back rent, you probably can't pay me the attorney's fees either. In a vast majority of eviction cases, I think if people really look at the statistics, nobody winds up paying anybody any money. The landlord just has to use the process and the procedure to get access to the premises to allow them to re-rent it to someone who's going to pay. That's just common sense. If I can't pay you the $1,000 or $2,000 or $3,000 or $4,000 that I owe you for the rent, and that's why you're evicting me, chances are I don't have an extra $1,000 or $1,500 or $2,000 to pay you for the attorney's fees as well. So what the amendment would do, as I understand it from the good gentleman from Washington County, is it would create that statutory allowance, essentially, for the court to say, in the absence of a contract fee-shifting provision, I can shift the fee to the tenant if it is determined that a good cause eviction existed. That's fair.
Floor Leader.
Thank you, Mr. Speaker. Sorry, I'm still getting used to saying that. I'm getting there. Thank you, Mr. Speaker. Yeah, so I appreciate that, and I agree with 90% of what was just said, that the vast majority of leases already have this in there. But I maybe disagree that any landlord can petition the court if they lose the case, and the court can decide whether to apply attorney's fees. What this amendment does is it requires the court, so it takes away any discretion. If the court were to determine that, in fact, the tenant lost, but they had some reason that they didn't want to apply attorney's fees, this would still require. So fully pulls away the discretion. While it is still possible that the attorney fees could get put on the tenant without this would require it of the court taking away their discretion. So I urge the body to resist the amendment.
The delegate from the Eastern Shore.
Yeah, on the amendment, I don't know if everybody realizes, but everything we're doing here today, and I think there's 13 or 14 other bills that are affecting landlords and what the landlords have to do and the responsibilities of a landlord. What that does for anybody who's never owned a building, who never leased anything out or rented anything, that raises the costs. They will have to make their money, they'll have to pay their bills. A simple thing like saying if you are found to be wrong, at least that's a deterrent. The bill was originally made for people who can't defend themselves. And this would limit some of the people coming up with false claims, and so we won't have to go to court and both parties spend the money. I think we got to be aware of the fact that this is costing, and with a time when we're looking for low-income housing and affordable housing, this isn't the answer. Thank you.
Delegate from Western Maryland.
Thank you, Mr. Speaker. Just to follow up a little bit, I think on any given session, this legislative body dictates what the courts can and cannot do. This is not asking for anything out of the ordinary. What we're facing is that landlords across the state are facing escalating financial pressures. I had a bill in Ways and Means that Washington County, we had a 40% increase in our assessments last cycle. 40%. Anybody here think that's okay? But that cost is borne by the renter because we have the homestead tax credit that applies only to owner-occupied rentals. So we're not going to help ease the pressure on the landlord or the tenant in that bill. We're not willing to help them here in picking up some of the costs of attorney's fees. Substantial increases are borne by the landlord in repair and maintenance costs, rising electric, water, sewer fees, insurance premiums, compliance costs, permitting fees, you name it. We're not doing anything in this body to help affordability crisis for rental properties by passing all these initiatives. So therefore, I press the amendment.
Question before the House is the adoption of the amendment. All in favor signify by saying aye. Aye. Opposed, no. The noes have it. We ask for a roll call.
Mr. Speaker?
Has everyone recorded their votes? Would anyone like to change their vote? Seeing that the clerk will take the call. With 80 votes in the negative, the amendment fails. Are there any further amendments to the bill or to its title? Delegate from Carroll County.
Thank you again, Mr. Speaker. I have an amendment at the desk. Amendment number 243-228-1.
Amendment number 1.
Move so much be considered the reading of the amendment.
So ordered.
Thank you. So basically, this amendment, if you look on page 7 of the bill, a landlord in good faith seeking to remove the leased premises for at least 1 year from the rental, as a rental, and it addresses that a landlord filing a legal action against a tenant, regardless of the disposition, is going to be considered just cause to terminate the lease. And as we've spoken numerous times by several of us here, this really is addressing the cost of being a landlord. And again, to echo what my friend from Western Maryland said, this is protecting the small mom and pop landlords that we have throughout the state. It is costly to go through this. And again, as I stated on the other amendment, you're talking about landlords who are trying to provide housing. They want to establish and build wealth for their family and income for their family in good faith. Good faith requires both parties to be in good faith. If you have someone who is not paying and gaming the system, which happens, again, the landlord must pay the mortgage. They must keep the property updated. They must pay the utilities if that's the way that that lease is written. These are all costs. And when you look at the length of time, at this point, I think it has been established, and we've gone over it several times on several amendments, you're talking about, on average, 3 months, possibly 4, before you can get your property back, and then you have to look at the cost of what happened to the property. Do you have to expend additional funds to get it back in rental standing? And at some point, a landowner, a property owner, a homeowner may say, I can't do this anymore. I cannot take this risk to be a landlord because the cost is too high. This is giving them an opportunity to say, this is good cause for me to move forward. I'm not going to rent this house anymore. I want out of this game. I think it's reasonable. Thank you, Madam Speaker.
You're welcome. Recognizing the floor leader.
Thank you, Madam Speaker.
You're welcome.
So I had a chance to explain one part of this bill, which is the stability that it creates in communities, in children's lives, in schools, because families aren't having to leave wherever they live every year for no good reason. There's a second reason that we have this bill, and that has to do with retaliation. Now, while I believe that the vast majority of landlords in this state are good landlords, are doing the best that they can, are trying to use the wealth that they have, growing their wealth, but also providing homes to people, the reality is there are landlords and there are property management companies that retaliate against tenants who complain, retaliate against tenants who organize, and I know from many properties within my district that have repeated problems with rats and broken heat and water leaking and one thing after another, who are afraid to raise the issue with their landlord because they are afraid that at the end of their lease, they will be asked to leave with no good reason. And so one of the things that this bill does for not all the good faith landlords in the state, but the handful of bad faith landlords in the state, is it protects tenants. If they are going to be asked to leave, then there needs to be a good reason given for why they're being asked to leave. What this amendment does is it says that all the landlord has to do if they want to get rid of a tenant is file a legal action against them. And regardless of the outcome, regardless of how frivolous that legal outcome might be, or that legal action might be, the landlord can then end their tenancy at the end of the lease. So clearly this flies in the face of the goal of this bill, which is one, to create the stability in communities, and two, to make sure that tenants aren't retaliated against should they raise issues with the landlord. So for those reasons, I urge the body to resist the amendment.
Recognizing the minority whip.
Thank you, Madam Speaker.
You're welcome.
If I could just offer some context here, and I rise obviously in support of the amendment. The way the bill is written now as amended, the tenant could be late, so the landlord sends to 4 10-day notices, but the tenant could be 29 days late 4 times in a row. So it's not just the tenant is 10 days late, the tenant could in theory be 29 days late 4 times, right? So for a landlord, whether they're hiring an attorney or they have an agent or they do it themselves, let me explain the process for filing a legal action in Maryland, right? So you have to download a form, fill it out, provide 10-day notice, post the notice on the property. They have to get the notice. You have to pay the sheriff. You have to schedule a court hearing in 3 to 4 weeks. You have to take a day off of work, show up to court, and then the tenant ghosts you, shows up. Right? Maybe the posting wasn't done right. Maybe they didn't get sufficient notice, so they reschedule. So now you've taken 2 days off work, and then let's say you're successful and you prevail and you get a judgment of possession from the court. Well, then you have to wait till the appeal period expires. Maybe that's 10 days, maybe that's 30 days, maybe the judge just forgets about it and doesn't actually rule on it for a certain amount of time. But then eventually the judge grants you a writ of restitution. So then you have to coordinate with the sheriff's office. Well, God forbid it's the wintertime because, for example, in some of our major cities, they don't evict if it's 38 degrees or below. That's a rule, 38 degrees or below. So now you can't evict the tenant for 4 months. So what we're asking landlords to do in some cases, and it could just be a mom and pop who happens to have 6 units, is they got to take multiple days off of work. They got to file all these filings. Maybe they hire an attorney to help with it, but it's a nightmare. The landlord-tenant process in the state, respectfully, because I do participate in that process, it's a nightmare. It's very difficult. And so, the amendment adds some guardrails because what we're saying is that, my God, if the mom and pop person goes the distance to file an action and the action doesn't result in a judgment, maybe there's a settlement. Maybe, and let me just tell you this, if you file a wrongful detainer, or if you file a failure to pay rent, 29 days later, if the tenant then pays you, the judge throws it out. So you've taken a day off of work, you've filed the action, you've posted on the property, you've done all these things, and then it's thrown out. And this is a vicious cycle, especially for tenants that always pay late. And so what the amendment is attempting to do is saying if somebody takes the time to file a legal action, that should be good cause. It really should. Because you've risen to a point now where someone is having to take legal action against you. And the way this bill's written, you'd have to do that 3 times. You'd have to file 3 different times in district court, take days off of work. I mean, it's a nightmare. And so for all those reasons and the practical scenarios in our state dealing with these landlord-tenant issues, this is a very reasonable amendment. So for those reasons, I support the amendment. Thank you, Madam Speaker.
You're welcome. Recognizing the floor leader.
Thank you, Madam Speaker. First, I want to clarify that the late payment of rent as a good cause in this bill does not require going to court. If a tenant is late on day 11, they pay their rent 4 times, and there's a receipt that shows that that's the date that they paid their rent, then a landlord can take those 4 receipts showing 4 times that they were late, take them to court at the time of the, or they can send, they don't even have to take them to court. They send that as the good cause of why they're having to end the lease, and that is the termination of the lease. The late payment of rent in this bill as a good cause does not require a single appearance in court. So that's the first thing. The second thing is what this amendment says is a landlord filing legal action against a tenant regardless of the outcome of the action. And so it is entirely possible that a landlord is filing a legitimate legal action, but it's also possible that the landlord is filing frivolous legal action, and this amendment would mean any landlord that wants to get rid of their tenant would simply have to file anything in court, whether it was accurate or not, and that would be good cause once that lease was over. So for those reasons, Madam Speaker, I urge you to resist the amendment.
The question before the House is the adoption of the amendment. All in favor signify by saying aye. Opposed, no. The clerk will call the roll.
Madam Speaker?
Madam Speaker,
Yes, recognizing the maker of the amendment.
to explain my vote.
Yes.
When you say for no good reason, as I said before, it takes 2 to make this a good transaction between the landlord and the tenant, number 1. And when you say frivolous lawsuits, I don't think a landlord's in the business of filing, of having to do frivolous lawsuits to protect their property. And again, when you go through it, you say it just the one time, again, it takes 3-4 months to go through the process. And a tenant, maybe a new landlord, someone who's bought a few properties and they go through this, maybe they bought 1, maybe they bought 7. Throw the number out there. I know it says up to 6. It may cost so much that they say, I can't do this. This is not worth it to me to be a landlord and provide housing to my community in good faith when I have to be going through this process over and over again. So again, I think this is a reasonable amendment, and I hope that you'll reconsider and put a green vote up there and help provide more housing for the citizens of Maryland. Thank you.
The clerk will take the call. There being 77 votes in the negative, the amendment fails. Are there any amendments, other amendments to the bill to its title? Recognizing the gentleman from Southern Maryland.
Thank you, Madam Speaker.
You're welcome.
Amendment at the desk, Amendment 203-423/1.
Amendment number 1.
So be considered reading of the amendment.
So order.
Thank you, Madam Speaker.
You're welcome.
Inside the bill, it does say for just cause substantial damage. If a tenant maliciously does substantial damage to your property, and then the tenant would have 14 days to rectify that. The problem is substantial damage is not defined. So my amendment seeks to define that as anything damage above the security deposit, which would be completely logical. So with that, I would ask that you accept that as a friendly amendment.
Recognizing the floor leader.
Thank you.
You're welcome.
Thank you, Madam Speaker. I guess
You're
she's up
welcome.
there today.
It's been a long day. I know. Hang
Thank
in
you,
there.
Madam Speaker. I urge the body to resist this amendment. There are, right now, there's several different ways that a destructive tenant could be required to, that a landlord could end the lease of a destructive tenant. So there's the substantial breach, there's substantial damage, and I know that's what this is getting at, but there's also sort of the general disruption of the livability of the premise, interference with the maintenance. So I think there's a good deal of flexibility in here when a tenant is causing problem to a property. There's a bunch of different ways that a landlord can document that, and that could end up being something that is in excess of the security deposit. It could actually be something that is less than the security deposit, and really in that way, this bill gives more flexibility to sort of the disruptive, the ability to end a lease with a tenant who's been repeatedly disruptive or destructive. So I urge the body to resist this amendment.
Recognizing the delegate from the Eastern Shore. I was trying to see which one.
Madam Speaker,
Yes.
the problem that I have with the preponderance of evidence, so we talked in committee quite a bit about how a landlord can prove or defend their position. And what the maker of this amendment is saying is that we're not defining a substantial, and then top that off with you're showing up in a court of law and you're having to share with a judge that there was not only damage done to your house, but you, by a preponderance of the evidence, have to show that it was substantial. And so what the maker of the amendment is trying to do is something that we talked at length about in our committee was make the bill workable. Show me what you mean by substantial when it comes to damage on property, because if the number one reason why a landlord goes to court is because there's not the payment of rent, the other reason is you're destroying my property. And destroying property could be, you know what, you went into the kitchen and you knocked a cabinet off the wall. All right, maybe you did something out of anger and you knocked a hole in the door. And all I'm saying to you is I doubt seriously that a judge is going to say that's substantial. But let me just tell you, and further, even if you did say as a landlord, hey, you can't be knocking cabinets off the walls. You can't be knocking doors off the hinges. Okay, imagine showing up in court with a picture and a judge saying, okay, it's one door in a house with how many doors do you have in there? Is that substantial? Well, you know, it is substantial because it's my house. My name's on the deed, and I expect the people living in the house to not do damage to my property. Now I've got to explain to a judge that it's substantial? Okay, and I believe that at the end of the day, what the maker of the amendment is doing is simply saying, make the bill workable, Madam Speaker, make the bill workable. If we're going to do it, let's make sure that the landlord has the ability with confidence to be able to make these legal conclusions. That's what this amendment is trying to do, make it easier for the landlord to do what they should be doing with the property with their name on the deed.
Floor leader.
Thank you, Madam Speaker. I think the gentleman sort of made the point for me, which is why we are not defining it tied to the security deposit alone. I think if a door is removed, even if that is less than the cost of the security deposit, that would count as substantial, and that would be the kind of thing we would want landlords to have the opportunity to have considered in court. So I think the combination of the protection of the tenant and the protection of the landlord, the balance that this list of good causes represent are the right balance with, and so for those reasons, I urge the body to resist the amendment.
The maker of the amendment.
Thank you, Madam Speaker.
You're
Could
welcome.
the floor leader please rise?
Floor leader.
So I just want to make sure I heard you for the legislative record, in case there's any lawsuits in the future here. So you just said if there's a hole in the door, that would fall under substantial damage?
I said if
Is that the legislative intent?
I said that I think if a door is destroyed so it's unusable, it seems to me that a judge would determine that to be substantial damage.
What happens if they don't?
Well, That's what, I mean, that judges make decisions that we like or don't like all the time. I mean, we write the laws to the extent that we can to provide the guidance to them, and sometimes we like the outcomes and sometimes we don't.
So you just answer your own questions. So you're defining substantial damage. It might be a hole in the door, in your opinion. In another judge's opinion, that's not a big deal. Don't we have it, shouldn't we define it a little bit better? And then there would take this ambiguity completely out of it. Because you could get in front of some judges that are just very sympathetic, where they destroy the entire house. Wouldn't that be a smarter decision?
I think what I'm trying to say about this list is that it is a flexible list. So this list is not supposed to lean towards the tenant. It's not supposed to lean towards the landlord. So what the list does is it creates a set of behaviors and patterns of behaviors that would identify someone as sort of problematic on the property. And it is purposely giving the flexibility, so some of them might be damage that is greater than the security deposit, some of it might be damage that's less than the security deposit, some of it might be patterns of behavior that make it unlivable for other tenants that don't have a financial value that's tied to the security deposit. So the balanced list that we have here is designed so that the good tenants who are not causing problems are not kicked out of their homes at the end of a year for no good reason, and those that are causing problems, the landlord has the ability to do that.
So I appreciate all that feedback about all these great lists that are inside the bill, but that's not what this amendment does. The amendment, and we're on the amendment, seeks to define what substantial damage is. You can't seem to tell me what substantial damage is. Let me ask you one follow-up question here. In the scenario that we've been laying out, where the tenant has caused damage, some people's opinion it might be substantial, other people's opinion not. I am seeking to define what substantial is. Let me ask you this question. Who is the victim in this case?
Who is the victim in which case?
In this scenario?
What I'm not sure which
Is the
scenario.
landlord the victim or is the tenant the victim?
Well,
the tenant is damaging the property. Who is the victim?
I think that what the bill is designed to do is to, what the bill is designed to do that the amendment would be added to is to create a set of protections, because sometimes the tenant is a victim of a situation where the landlord is choosing to remove them from the property without any just cause. And in those kinds of situations, the tenant would be the victim. I think other times when there's damage to property or where there's problems on the property, the landlord is the person who experiences the harm. I'll go with harm instead of victim, since we're talking about civil situations.
I'm going to use the term victim here because I asked you, because this one we're on the amendment. I would think that the person that was receiving substantial damage to their property is the victim.
And that's why that's why that is a reason that they can be, that is a good cause. If that has happened, then that is a good cause at the end of that lease. But I actually want to back up and just say, because this is a point that I've made a few times that I just think is super important. A lot of the points that have been made about some of the amendments suggest that this legislation takes the place of every other landlord-tenant law and takes the place of every other lease that's out there. If a tenant is causing substantial damage on an ongoing basis to a property, that is a violation of the lease. There are a series of legal steps that that landlord can take to address that, including, in some situations, eviction. So all of the leases that currently exist still exist. All of the landlord-tenant law that currently exists still exists. This is about setting a set of reasons that at the end of a lease, a landlord can or cannot ask a tenant to leave.
Thank you. Thank you for answering these questions. More confused than when I started, but thank you. It's interesting because if you have malicious property damage, somebody's property you don't know, it's actually a misdemeanor with 60 days in jail. And if it's over $1,000, it's 3 years with a fine up to $1,500. You go to jail if you destroy somebody else's property. But if you're trusted and have a lease agreement, we can't even define it. We refuse to define it even as a 1-month security deposit, which is what this amendment does. Think about that. If it's greater than the security deposit, then yes, absolutely, the landlord is the victim in this case, and this legislation is further victimizing them. They are experiencing financial harm. This is common sense. The amendment does nothing more than say that if excess damage more than the security deposit, that is grounds for eviction. Doesn't say they have to execute it. It's up to the landlord's decision. This is what we would call common sense. I'd ask for a green vote. I'll move the amendment, Madam Speaker.
The question before the House is the adoption of the amendment. All in favor signify by saying aye. Opposed, no. The noes have it. The clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? The clerk will take the call. There being 76 votes in the negative, the amendment fails. Are there any additional amendments to the bill as to its title? Recognizing the gentleman from the Eastern Shore.
Thank you, Madam Speaker.
You're welcome.
I have an amendment at the desk. Amendment number 153525/1.
Amendment number 1.
Thank you. On page 3 of the bill, lines 3 to 5, it says the full legal name of each individual and the business name of each entity with direct or indirect ownership or membership interest in the residential rental unit must be in a report. To me, that sounds like an LLC, and my amendment is pretty simple. I'm trying to strike the LLC out of this bill. You can actually go to the landlord or the resident agent to do this, and people really have to understand that the biggest businesses we have, our vast majority of employers, are small businesses in this state. And 40% of those small businesses are LLCs. So as you start to pick at this and start to understand that you're now destroying probably one of the biggest business centers we have, probably the biggest job creator we have in the state. You think what an LLC does and what they allow. They sit back and they get people to invest, and they try to bring all the parties together, which will give jobs and innovation and competition. So I move the amendment. It's pretty simple, pretty clear cut.
Thank you. The floor leader.
Thank you, Madam Speaker.
You're welcome.
Thank you for the amendment, my friend. I just want to explain what this section of the bill does. So in putting this bill together, there was a determination that landlords who own 6 or fewer properties, that this would not apply to them. And so landlords need a process by which they can get that exemption. This is going to apply to all landlords with more than 6 properties. Then those with 3 properties need a way to be able to articulate that they only have 3 properties and therefore this doesn't apply to them. So what the bill does is it says that the Office of Landlord and Tenant Affairs will create a form that landlords can use, and it's basically a form that they use. They fill it out, and this says, I only own 3 properties, here they are. I only own 4 properties, here they are, and now I'm exempted. The reason that LLCs are brought into this is because it would be possible for a landlord to own 7 properties with 7 different LLCs, and so because each of the LLCs has a different name, they could say, okay, no, this is, my LLC only owns this one right here, or maybe I own 4 LLCs with this sister and 2 LLCs with my brother and 2 more with my mother. And so in order to make sure that folks are not taking advantage of the small landlord exemption, it's necessary for people to sort of disclose on this form their various holdings. And so without this, essentially any landlord could just say, this bill doesn't apply to me, and then the bill wouldn't apply to them. So this is a really important piece of it in order to keep the exemption in there, and so it's an important piece to make sure that we're applying it to the appropriate folks. For those reasons, I urge the body to resist the amendment.
Recognizing the minority leader.
Thank you.
You're welcome.
Madam Speaker. I create a lot of LLCs over my career, over my lifetime. Hundreds, definitely. And I get what, and I had an opportunity to speak to my very good friend, my committee chair, the sponsor of the bill, about the LLC issue before, and I get, kind of what they're talking about. The Kushner enterprise, people that own, thousands and thousands and thousands of units and have hundreds of LLCs and are represented by New York City law firms. But LLCs are also, I think, two things that the chamber should understand. Under Maryland law, you are not required to disclose to the state of Maryland who the members of an LLC are. When you create an LLC, you file something called the Articles of Organization. It is a one sheet. Mainly what the state of Maryland is concerned about is getting your money. You can file as many LLCs as what you want, but every one you file costs you $300 and some bucks, and every year, regardless of whether it's just a piece of paper LLC that owns nothing, you have to pay the state of Maryland $300. It is another tax that we have created. I once had a client that looked back, and because he'd been involved in various developments, many of which never got off the ground, but LLCs were formed to pursue the financing. He had over 100 LLCs and was paying $30-some thousand a year to the state of Maryland for nothing, essentially, for the right to exist and have pieces of paper. And so what this amendment, I think, seeks to do is to not get us out of conformity with Maryland law. So if you have someone who chooses to become an owner-operator of multifamily housing, and we have all suggested all session long that we need more people in the multifamily housing sector because we need more affordable housing for people who can't go out and have hundreds of thousands of dollars and qualify under today's mortgage rates to buy homes. We have to have more housing for them in apartments, townhouses, whatever it is. But if you have someone who's an investor in this sector in an LLC today, they're taking on an additional burden under this amendment of, well, you don't have to disclose, and I'm not joking about that. All you have to put on the Articles of Organization is who is the registered agent for service of process. I could own an LLC with this gentleman and this gentleman and that gentleman and all over this room, and none of those names get listed. None of them. The state of Maryland doesn't get any of the information. When you file your K-1, if there's profit, it's going to be on there to the IRS. The state of Maryland doesn't have the information. So now we're saying all of those individuals and all those companies have to go back, determine who their owners are, individuals or other LLCs, and then file them with this regulatory body so that the regulatory body can track down and see whether or not the just cause law applies to them. It is going to be bureaucracy upon bureaucracy. And I'll tell you something else. I appreciate my colleague from Montgomery County's example of how you could potentially own LLCs, but there are also a lot of people who they might only own 5 or 10% of 2 or 3 LLCs. They don't have operational control of the LLC. We call them investors. And they're like, hey, I'll give you $50,000 and I'll own 10% of your LLC. I don't have any control over it. I don't control the units. I don't control who gets evicted. And we might have 10 units under that LLC that I invested my money in. And then on top of that, I on my own chose to renovate a duplex that I used to live in Rockville. And I rent that duplex out. That's 2 units. Under this law, as I understand it, that person now becomes a major landlord subject to the law. They invested $50,000 in an LLC that owns 10 units that they have no control over, that they don't make a single decision for because they're a minority investor. And then they have a duplex that has 2 units, but when they file this paperwork, they say, nope, you're a big landlord subject to the same rules as Kushner Enterprises. The just cause law applies to you. That's not the way to do this under the law. If you want to do it, you should have provisions for controlling interests and affiliated companies if we're all the same and we're just going under different names. And people do that. You know, one person can own 100 different LLCs, as I just gave you the example. If that's what you're trying to get at, you should do that in a sharper, more intelligent way, because this way is going to trap a lot of people in there that are going to be subject to the requirements of this law that are in no way, shape, or form major landlords simply because they and their lawyers have crafted ownership interest in LLCs. It's not a good idea.
Madam Speaker.
All right. The gentleman from Baltimore County.
Thank you, Madam Speaker. Will the floor leader rise for a question or two?
Thanks.
Hi there. I'm confused because a few times in the last exchange there, you're using the word properties, but the bill, and I think this gets to one of the points the minority leader was making, is it properties or is it units?
It's units.
Okay, so for clarity, someone could own 2 townhomes, second floor is a unit, the first floor and the basement is a unit in one,
Three.
and right, and then
Yep.
another townhome, and that's your 6 units there, right?
That's
so
6
okay,
units.
okay.
Yep.
So just for clarity, so another question I have: how does this work? And I think this also goes to the minority leader's point. How does this work with out-of-state LLCs or corporations? So let's say I've got a Montana LLC, which are basically completely untrackable. How would we make this work with something like that?
I think that if your Montana LLC owns property in Maryland, in the state, so just to be clear, if your Montana LLC owns 5 properties in Montana and 1 property in Maryland, or some version of that, right, you would be filling out this form. And I think the details of it, this directs the Office of Landlord-Tenant Affairs at DHCD to actually develop the form. So I think there will be some nuance to how they're going to figure these pieces out. But if you own property in the state, now if you own property in the state and you want to just, well, first of all, let me also say, in a county that has adopted good cause, right? So that's really important. So we're not talking about this happens and this goes across the state as soon as we pass the bill. We pass the bill and then a local county has to enable it locally. Once that happens, if you have a property in that county, you can either say, okay, the county now has good cause as the law, now I'm going to follow good cause. Or you can say, no, I own 1 property, I own 2 properties, so the law doesn't apply to me. Then you go get the form, you fill it out, you say my LLC has a Montana base, whatever. You put that on the form, and off you go, and the law doesn't apply to you.
Okay, so how does it work though if I've got 5 different Montana LLCs? Because again, you can look this up. I mean, they're basically completely unknowable who owns those. How do you square that? Who owns each one of those Montana LLCs? And there's a couple other states, but Montana's the big one. There's a few other states though that are like this. How do you square that in that
You're talking about
circumstance?
Montana LLCs that own property.
That own
in the state
property
of
in Maryland. So I've got Montana LLC 1, Montana LLC 2, 3, 4, 5.
So ownership of property in the state of Maryland would kick in Maryland laws as it relates to that property. And so the Department of Landlord Affairs would have to figure out on this form how they're going to require the disclosures for an LLC that is based elsewhere in the country but owns property in Maryland.
Okay, so, but I think what I'm hearing you saying, and the point that I'm making here is, it's very hard, if almost impossible, for us in Maryland, because I sat on the committee before that had this with these Montana LLCs, to know who owns them. It's very difficult. So I think that there is a giant loophole that someone could drive through here with that. I do have another question though.
Can I answer
Sure,
that question?
Sure.
I think the point is that if you cannot make the case that you own or your LLC owns or however it is 6 or fewer properties in the state of Maryland, then the law applies to you. And if you want to get that exemption, then you have to make that case. And so if you have LLCs all over the country and in Montana, and you're not willing to disclose ownership of those LLCs, then the law applies to you. So it's not a loophole. I mean, it may be a little bit more complicated. There's a form that gets created, you fill it out or you don't, and if you don't, then the law applies to you. It's not actually that complicated.
Okay, I still think there's a substantial amount of ambiguity, but I do have another question because you brought up a point about jurisdictions being able to set their own policies here. So as I understand it, we essentially could have 24 different rules in place.
No.
I've used this example before, and I'm just curious how this would work. So say I have an apartment complex that straddles 2 different jurisdiction lines. So some of the apartments are in jurisdiction A and some are in jurisdiction B. What happens there in that circumstance?
Sorry, let me clarify. Local counties cannot all set their own rules. They can either adopt this or not. So it's enabling legislation, and a local county says, I want good cause. This is good cause. This is the list you have to take. Or a local county says, I don't want good cause. Nothing happens. So you either have it or you don't. So there's 2 options. There's not 24 options.
Okay. Well, okay. Let me rephrase then. Same example. Got one county deciding to do one thing, another county deciding to have a different policy. Straddles the line. What happens there? What happens in that circumstance?
What if a unit is in? It's this. There are different laws related to property. There's different laws that counties have in all kinds of areas, including in property requirements, health and safety codes, those kinds of things. Anything that's not done at the state level that's passed on to the county has the ability to set different property rules. So if you have a building that straddles the units that are in one are under those rules, and the units in the other are under those rules. And so the same would be true for this if you have one county that enables the law and the other that doesn't.
Why would it not be beneficial to have continuity of law? So to say, look, we're the state legislative body. Why not have one continuity of law versus?
So do you have an amendment? I've got like 20 amendments here. I haven't seen the one that makes this not enabling and instead just makes it state law. But if you want to bring that amendment, I would accept it as a friendly one.
So I think what I'm getting at here is, no, I mean, I'm not bringing that amendment, but what I'm saying is that, like I made the point about another bill, right? I think that when we're creating state policy, to have all these different, I mean, you theoretically could have multiple different looks going on in one region potentially, right? I mean, I have a district that goes across two lines. You could have a lot of different things going on. I think it's confusing for landlords.
Some folks think that local control is a good thing, and I think that our balance here in the body is to decide what things we think should be statewide policy and what things we want to sort of offer to the locals for local control. And I think that we can agree and disagree where those lines are, but I think this is an area where we've determined that we can enable it and there can be local control. But I want to come back to the amendment because that's actually what we're debating, and the amendment is related to disclosure laws. And so I think we've talked, the disclosure part of the law. So I think we've talked a lot about why it's necessary to have a process for folks who want to get an exemption from the law. I think that probably your additional comments about variability across the state may be third reader sorts of disagreements that you might have with the bill. So, Madam Speaker, I urge that we resist this amendment.
Sure. Thank you, Madam
The question before the House is the adoption of the amendment. All in favor signify by saying aye. Opposed, no. The clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? The clerk will take the call. There being 77 votes in the negative, the amendment fails. Are there any additional amendments to the bill as to its title? Recognizing the gentleman from Southern Maryland.
Thank you, Madam Speaker.
You're welcome.
I have an amendment to the S733221, number 1.
Amendment number 1.
So much be considered the amendment, ma'am.
So order.
So,
what was it? What was it? Go ahead, so order.
We're getting late and tired, and I'm waiting for my Easter bunny and my candy and my Easter stuff. Anyhow.
It's okay.
Thank you, ma'am. One of the things that we recognize in Maryland now is that we're 90,000 units short. And that's a lot of housing out there. And we would try, I think, in my mind, to be encouraging investment. Now, one of the things we want to be able to do also is encourage investment in Maryland and keeping money in Maryland versus everybody deciding, well, we should be leaving Maryland. So my very simple amendment simply says that I would like to have, instead of having 6 units per landlord, 15 units per landlord to encourage investment, opportunity in Maryland, particularly for people who are young, entrepreneurial in nature, and feel this is a good way to conduct business. And with that, ma'am, I move the amendment.
All right. Madam Floor Leader.
Yeah, thank you, Madam Speaker. I urge the body to resist the amendment. I think, again, this is a sort of balancing act of where do you draw the line. We really want to have the stability in communities, in schools, and families that I was talking about earlier for the vast majority of renters. I think the landlord-tenant law right now, real property law 5, is sort of the sweet spot of when you have more than 5. You have to have a written lease, and a bunch of other rules that we have as it relates to landlord-tenant law kick in. And so I think in, again, balancing, you have the mom and pop with the 2, properties, maybe you have more flexibility there, but in general, our real estate law has that more than 5 is usually where you start to have the protections that we have in leases and so on kick in. So for that reason, wanting to make sure that the vast majority of renters benefit from the kind of stability that we're creating with this law, I urge the body to resist the amendment.
Move the amendment, Madam Speaker.
The question before the House is the adoption of the amendment. All in favor signify by saying aye. Opposed, no. The clerks will call the roll.
Madam Speaker?
Has everyone recorded their vote? The clerk will take the call. There being 76 votes in the negative, the amendment fails. Are there any additional amendments to the bill as to its title? Recognizing the gentleman from Anne Arundel.
Thank you, Madam Speaker.
You're welcome.
Well, here we are. It is 4:48 on Friday evening, and this is what I would expect to be the last amendment. It is number 603727/1.
Amendment number 1.
Move so much be considered the reading of the amendment.
So ordered.
Thank you, Madam Speaker.
You're welcome.
You know, body, serving on the Veterans Caucus for the last 4 years has been one of my highest honors while in this body. Currently, my bigger baby brother is an active duty Navy sailor with nearly 20 military installations here in the state of Maryland and over 100,000 active duty soldiers. We must protect our heroes and encourage them to come home after they may leave to PCS or to deploy. This amendment adds that it may not apply to a landlord who is an active service member as defined in 9-901 of the state government article. This is to help bring our soldiers back. They may have a short period of time where they need to rent their unit, and this allows them to return home and protects them under this bill, and I move the amendment.
Floor Leader.
Yeah, thank you, Madam Speaker. So I think the landlord, I'm not sure if I understand exactly the amendment. So first, let me just begin by thanking your family for sacrifice and appreciating all of the active duty military and veterans both in this body and across the state. And I think that this amendment isn't necessary. I urge the body to resist the amendment because the landlord can already, if it's a personal property that the landlord wants to move into or wants to move any of their family members into, they already have the ability to take possession once the lease is over. So if we're talking about an active duty military member who was renting while they were in another state or another country, now they're coming home, they have the ability to end the lease. Second, another scenario I think maybe you're thinking is they're being deployed and they want to sell very quickly and they're worried that they can't sell because they've got this lease on it. Again, if it's an active duty military with one home that had been theirs and then they were renting and now they're moving and now they're selling, I think that that you'd be talking about one property. I think an active duty military member that's involved in the business of rental property with 6 or more units is a very different scenario than an active duty member who has 1 or 2 that they were using for themselves and their family. And so while we certainly understand the flexibility needed for the for that situation, an active duty member in business in Maryland with 6 properties would still need to abide by Maryland law as it relates to renter protections.
Recognizing the gentleman from Anne Arundel.
Thank you, Madam Speaker. No,
You're
it's
welcome.
not different, and I'll tell you why. Active duty means many different things, especially to us service members who were called up on, let's say, 9/11, and then spent 14 months away from home at a moment's notice based on presidential orders and being deputized at the impact area at the Pentagon. So no, it does not mean that, number one. And number two, we do have active duty members and or National Guard members that do own many properties. And it's not because they plan on being a landlord conglomerate or owning property in Pork Band, Utah, or wherever we were talking about a half hour ago. It's the fact that they will be PCS from base to base to base, and in doing that, they will buy a property and then rent it out as they move to another base, including right here in Maryland. So I understand what you're saying about the 6 versus 5 protections built into the bill, but they should not apply to military, active or otherwise, and because we are called up at a moment's notice. We live in a very different world than we did in the 90s. I think 2001 proved that, and other things have proved that. So I do think that this is a friendly amendment, and I ask the body on behalf of members who do get called up at a moment's notice to accept the amendment as friendly. Thank you, Madam Speaker.
Recognizing the floor leader.
Thank you, Madam Speaker. I think that if an active duty military member has property in the state and then has to go someplace else to serve, presumably they have someone managing their property. I don't imagine they're just going to kick everyone out of their properties and leave them empty, leave 6 or 7 or 10 properties empty while they're traveling or while they're serving in another location. So if they have property, they are required to follow Maryland landlord-tenant law, and there's nothing about this landlord-tenant law that would be different than that, unless it was that they need to come home and get their property back to live in, which is already taken care of in the law. So for those reasons, Madam Speaker, I urge the body to resist the amendment.
Recognizing the minority whip.
Thank you, Madam Speaker. Look, I'm very proud to come from a big military family. I spent the first half of my life literally moving every 2 years because my dad got orders. Active duty, we got orders. We lived in Europe. We lived in Asia. We just went where the government told us to go. And I'm proud to see a lot of my colleagues here are veterans, right? But we're talking about 2 townhomes, right? This isn't Jared Kushner getting called up to duty. This is 2 townhomes, right? 2 townhomes that happen to have 3 units in them. The active duty member gets ordered to go to combat, gets ordered to move to a different country. Why could we not accommodate this person? They may need to dispose of these rental units when the lease ends. This whole bill is about not allowing a lease to end. So why would we not allow an active duty member who gets ordered to go to combat to end a lease that's supposed to end anyways? That's what we're talking about. It's a minor exception. Active duty members, I'm proud to represent 18,000 veterans in Frederick County. I'm proud to live in a state that has all these military installations. This is a minor concession. If you have an active duty member, my God, they get ordered to deploy. Let's help them out, right? I support this amendment. Thank you.
The question before the House is the adoption of the amendment. All in favor signify by saying aye. Opposed, no. The clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? The clerk would take
Explain my vote.
the call.
Maybe next time.
Sorry, next time. There being 71 votes in the negative, the amendment fails. Are there any additional amendments to the bill as to its title? Hearing none, the bill is order printed for third reading. All right, we have special order calendar, Senate Bill 417. I'm going to ask the clerk to read the bill, please.
Senate Bill 417, Labor and Employment, Mandatory Meetings on Religious or Political Matters, Employee Attendance and Participation, Maryland Worker Freedom Act. Favor report adopted.
Recognizing the maker of the motion, who is the minority leader.
Thank you, Madam Speaker.
You're
all
welcome.
of my questions and unfortunately all of our amendments were laboriously answered in earlier today on the cross file of the bill, and so therefore I would withdraw the special order, and this bill would stay in the same procedural posture.
Thank you. Hearing no other amendments to its title, the bill is order passed for third reading. Quorum call.
Madam Speaker?
It's okay. It's okay. Give people a minute to reach their seats. Has everyone recorded their presence? If so, the clerk will take the call. There being 116 members present, the House is still in session. Thank you. House third reading, calendar number 128. The clerk will read the bill.
House Bill 74, State Procurement, Security Services, Contract Modification.
House Bill number 74 is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 86 votes in the affirmative and 29 votes in the negative, House Bill number 74, having received a constitutional majority, is declared passed. So clerk will read the next bill, please.
House Bill 896, Military Department National Guard State Active Duty Mobilization Fund.
House Bill number 896 is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk. You voted? Yes? We'll take the call. There being 110 votes in the affirmative and 7 votes in the negative. House Bill number 896, having received a constitutional majority, is declared passed. The clerk will, House third reading calendar, Senate bills number 13. The clerk will read the first bill, please.
Senate Bill 38, Vehicle Laws Ignition Interlock System Program, required participation.
Senate Bill number 38 is on third reading and final passage. Are there any amendments to the bill as to its title? Any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? The clerk will take the call. There being 116 votes in the affirmative and 0 votes in the negative, Senate Bill number 38, having received a constitutional majority, is declared passed. The clerk will read the next bill, please.
Senate Bill 81, Criminal Law School Resource Officers, Prohibition on Sexual Activity with Students.
Senate Bill 81 is on third reading and final passage. Are there any amendments to the bill as to its title? Any debate? Hearing none, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? The clerk will take the call. There being 117 votes in the affirmative and 0 votes in the negative, Senate Bill number 81, having received a constitutional majority, is declared passed. The clerk will read the next bill, please.
Senate Bill 82, Criminal Law Counterfeiting and Possession of Counterfeit Lease of Real Property Penalty.
Senate Bill number 82 is on third reading and final passage. Are there any amendments to the bill as to its title? Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? The clerk will take the call. There being 119 votes in the affirmative and 0 votes in the negative, Senate Bill number 82, having received a constitutional majority, is declared passed. So clerk will read the next bill, please.
Senate Bill 131, Estates and Trusts, Fiduciaries, Attorney-Client Privilege.
Senate Bill 131 is on third reading and final passage. Are there any amendments to the bill as to its title? Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? The clerk will take the call. There being 119 votes in the affirmative and 0 votes in the negative, Senate Bill 131, having received a constitutional majority, is declared passed. The clerk will read the next bill, please.
Senate Bill 177, Criminal Law Obstruction or Interference with Exercise of Religious Beliefs Prohibition.
Senate Bill number 177 is on third reading and final passage. Are there any amendments to the bill as to its title? Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? The clerk will take the call. There being 119 votes in the affirmative and 0 votes in the negative, Senate Bill number 177, having received a constitutional majority, is declared passed. The clerk will read the next bill, please.
Senate Bill 182, Adult Protective Services Modifications.
Senate Bill 182 is on third reading and final passage. Are there any amendments to the bill as to its title? Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 120 votes in the affirmative and 0 votes in the negative, Senate Bill number 182, having received a constitutional majority, is declared passed.
Madam Speaker?
Yes, recognizing the gentleman from Montgomery.
Thank you, Madam Speaker.
You're
My
welcome.
button didn't work. I'd like to be recorded in the green for Senate Bill 81.
Okay, make sure you have your yellow slip. Thank you so much. Anyone else for vote change? All right. So we have Senate third reading calendar number 14. The clerk will read the bill, please, the first one.
Senate Bill 250, Estates Maryland Uniform Simultaneous Death Act.
Senate Bill number 250 is on third reading and final passage. Are there any amendments to the bill as to its title? Is there any debate? If not, the clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 119 votes in the affirmative and 0 votes in the negative, Senate Bill number 250, having received a constitutional majority, is declared passed. The clerk will read the next bill, please.
Senate Bill 277, Estates and Trust Venue for Administrative and Judicial Probate and Application of Inheritance Tax.
Senate Bill number 277 is on third reading and final passage. Are there any amendments to the bill as to its title? Is there any debate? If not, the clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? If not, the clerk will take the call. There being 119 votes in the affirmative and 0 votes in the negative, Senate Bill number 277, having received a constitutional majority, is declared passed. The clerk will read the next bill, please.
Senate Bill 395, Peer-to-Peer Car Sharing Programs, Insurance and Liability.
Senate Bill number 395 is on third reading and final passage. Are there any amendments to the bill as to its title? Is there any debate? If not, the clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 120 votes in the affirmative and 0 votes in the negative, Senate Bill number 395, having received a constitutional majority, is declared passed. The clerk will read the next bill, please.
Senate Bill 397, Anne Arundel County Sheriff Appointment of Majors.
Senate Bill number 397 is on third reading and final passage. Are there any amendments to the bill as to its title? Is there any debate? If not, the clerk will call the roll.
Madam Speaker?
The clerk will take the call. There being 120 votes in the affirmative and 0 votes in the negative, Senate Bill number 397, having received a constitutional majority, is declared passed. The clerk will be so kind and read the next bill, please.
Senate Bill 437, Criminal Law, Theft and Fraud Crimes, Valuation and Forgery of Gift Cards.
Senate Bill number 437 is on third reading and final passage. Are there any amendments to the bill as to its title? Is there any debate? If not, the clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? The clerk will take the call. There being 120 votes in the affirmative and 0 votes in the negative, Senate Bill number 437, having received a constitutional majority, is declared passed. The clerk will read the next bill, please.
Senate Bill 465, Criminal Procedure, Admission of Out-of-Court Statements, Assault in the Second Degree.
Senate Bill number 465 is on third reading and final passage. Are there any amendments to the bill as to its title? Is there any debate? If not, the clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? The clerk will take the call. There being 117 votes in the affirmative and 0 votes in the negative, Senate Bill number 465, having received a constitutional majority, is declared passed. The clerk will be, actually, we are going to Senate third reading calendar number 15. The clerk will read the first bill, please.
Senate Bill 531, Criminal Procedure, Victims of Sexually Assaultive Behavior, Request for Verbal Acknowledgement, Verbal Waiver Transparency Act.
Senate Bill number 531 is on third reading and final passage. Are there any amendments to the bill as to its title? Any debate? If not, the clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? The clerk will take the call. There being 118 votes in the affirmative and 0 votes in the negative, Senate Bill number 531, having received a constitutional majority, is declared passed. The clerk will read the next bill, please.
Senate Bill 544, Courtroom Security, Minimum Adequate Security Standard.
Senate Bill number 544 is on third reading and final passage. Are there any amendments to the bill as to its title? Hearing none, the clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? Does anyone care to change their vote? The clerk will take the call. There being 120 votes in the affirmative and 0 votes in the negative, Senate Bill number 544, having received a constitutional majority, is declared passed. Recognizing the lady from Prince George's County.
Madam Speaker, my button didn't work on 531. I'd like to be recorded in the green.
All right. Make sure we get the yellow slip. Anyone else for vote change?
Madam Speaker.
Recognizing the gentleman from Baltimore.
Thank you. My button also didn't work on HB 74. I wanted to make sure I was in the red.
All right. Yellow slip, please. Anyone else? All right.
Madam Speaker.
Yes. Oh, recognizing the gentleman from the Eastern Shore.
Thank you. My button
You're
didn't
welcome.
work on 531. I'd like to be in the green.
All right. Thank you. Will the clerk be so kind and read the next bill?
Senate Bill 634, Office of the State Prosecutor, Investigation of Threats, Judges.
Senate Bill number 634 is on third reading and final passage. Are there any amendments to the bill as to its title? Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? The clerk will take the call. There being 120 votes in the affirmative and 0 votes in the negative, Senate Bill number 634, having received a constitutional majority, is declared passed. The clerk will be so kind and read the next bill, please.
Senate Bill 637, Maryland Automobile Insurance Fund, Fund Producer Commission Rate.
Senate Bill number 637 is on third reading and final passage. Are there any amendments to the bill as to its title? Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? The clerk will take the call. There being 116 votes in the affirmative and 3 votes in the negative, Senate Bill number 637, having received a constitutional majority, is declared passed. The clerk will read the next bill, please.
Senate Bill 715, Washington County Juveniles Truancy Reduction Pilot Program.
Senate Bill number 715 is on third reading and final passage. Are there any amendments to the bill as to its title? Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
The clerk will take the call. There being 120 votes in the affirmative and 0 votes in the negative, Senate Bill number 715, having received a constitutional majority, is declared passed. The clerk will read the next bill, please.
Senate Bill 745, Police Training, Autism and Dementia.
Senate Bill number 745 is on third reading and final passage. Are there any amendments to the bill as to its title? Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
The clerk will take the call. There being 119 votes in the affirmative and 0 votes in the negative, Senate Bill number 745, having received a constitutional majority, is declared passed. The clerk will read the next bill, please.
Senate Bill 907, Public Health Female Genital Mutilation.
Thank you. Senate Bill number 907 is on third reading and final passage. Are there any amendments to the bill as to its title? Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? The clerk will take the call. There being 120 votes in the affirmative and 0 votes in the negative, Senate Bill number 907, having received a constitutional majority, is declared passed. Message from the Senate. Senate bills introduced in the House. The clerk will read the bills and committee assignments.
Senate Bill 1007, Senator Zucker, House Rules, by Order of Sylvia Seeger, Chief Clerk.
Yea and nay, consent calendar number 2. House bill passed in the Senate. The clerk will read the first bill.
House Bill 225.
Recognizing the majority leader.
Thank you, Madam Speaker. So
You're welcome.
So much we consider the reading of House Bill 225 be considered reading for all the bills on the calendar.
So order. Introduction of House Simple Resolution during the last 35 days of session. On recognizing the sponsor of this simple resolution, the delegate from Hartford County.
Thank you so much, Madam Speaker.
You're welcome.
I really appreciate the opportunity to explain to the body why I have late introduced this resolution. Madam Speaker, we have a lot of folks on the floor today who are fighting for their lives. They are sick, they may have cancer. We have folks who have lost family members who are sitting here on the floor today who are grieving. They're here because the work we do is incredibly important to the people of the state of Maryland. Not only that, but in the Judiciary Committee, as I'm sure the Speaker would agree, we do really important work.
You do.
Thank you. And there are many legitimate reasons why folks may not be able to be here. They may be sick or may have personal reasons why they are unable to be here today, or during committee meetings or subcommittee meetings. But those folks who should be here who do not have a legitimate reason, who are simply refusing to come because they claim it is harming them financially,
Speaker,
or that
point of order.
Recognizing the gentleman, the chair of the committee, please.
Thank you, Madam Speaker. I'm happy to yield to the deputy parliamentarian, but I think the question is why is the bill late, not why is it a good resolution?
Yes, I'm explaining why the bill was late filed because of the events that have occurred in the last few days in our committee. So, if I may, Madam Speaker.
Continue.
The work of our committee is important, and the absence of one of our members has, on more than one occasion, caused our committee or our subcommittees to be delayed in starting because it is hard to find a quorum while members are legitimately doing the work of the people in the Senate chamber or in other committees. So with that in mind, Madam Speaker, I have introduced this late filed resolution so that I might have the opportunity to explain to the Chair of Rules and the rest of the body why I believe that the absent delegate from Carolyn Frederick should be expelled from the chamber.
So the question for the body is, shall the House simple resolution be introduced? It requires 95 votes. The clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? If so, the clerk would take the call. There being 102 votes in the affirmative, the House simple resolution will be introduced. The clerk will read the House simple resolution and the committee assignment.
House Simple Resolution 2, Delegate Erickson, House Rules.
This ends the work of the desk. Committee announcements, appropriations.
Thank you, Madam Speaker. The Appropriations Committee is not meeting after session or Monday morning.
Economic matters.
Economic Matters is not meeting this evening.
Environment and transportation.
Thank you, Madam Speaker. The House Environment and Transportation Committee is not meeting before the next floor session, but listen up for subcommittees.
Government, labor, and elections.
Thank you, Madam Speaker. The Government, Labor, and Elections Committee will not meet either this evening nor Monday morning.
Health.
Thank you, Madam Speaker. The Health Committee will not be meeting today, but will meet an hour before floor session on Monday for a voting session.
Judiciary.
Thank you, Madam Speaker. The Judiciary Committee will be meeting at 6 p.m. tonight.
Ways and Means.
Thank you, Madam Speaker. The Ways and Means Committee will not meet tonight.
Subcommittee announcements. Recognizing the Rules Committee.
Sorry.
Chair.
Thank you very much, Madam
Can we
Speaker.
just, 1 second.
Madam Speaker.
1 minute, please. Hold on 1 minute. We're still in session. We're almost done, and we got here earlier than I expected.
Okay.
So let's just hang in there tightly. We're almost done. Recognizing the Chair of the Rules Committee.
Thank you very much. Ladies and gentlemen of the House, the Rules Committee will be meeting for a public hearing on 2 bills and some re-referrals on Monday at 2 o'clock in the afternoon in the Environment and Transportation Committee room. Okay, I'm going to repeat that so everybody hears it. The Rules Committee will be meeting for a public hearing and re-referrals on Monday afternoon at 2 p.m. in the Environment and Transportation Committee room. Thank you.
You're welcome. 2 p.m. Recognizing the Chair of the Environment and Transportation Committee.
It's actually a subcommittee announcement, Madam Speaker.
Yes.
On behalf of the Energy Subcommittee Chair, the Energy Subcommittee will be meeting tentatively 1 p.m. on Monday.
Thank you. Recognizing the Chair of the Health Committee.
Thank you, Madam Speaker. In light of the recent announcement, the Health Committee will be meeting at 1 p.m. on Monday for a voting session.
Recognizing the gentleman from Baltimore County.
Thank you, Madam Speaker. The Environment Subcommittee will be meeting at 2 o'clock on Monday.
Any other subcommittee announcements? Recognizing the delegate from Prince George's.
I apologize. Vote change, Madam Speaker. SB 465, yea to nay.
Recognizing the gentleman from Baltimore County.
Thank you, Madam Speaker. My finger didn't work on SB 637. I'd like to be recorded in the yea, please.
Anyone else for vote change or subcommittee announcements? Seeing none. Any delegation announcements? Seeing none. Any caucus announcements? Seeing none. Any personal guest announcements? Seeing none. Let's thank the pages. Will they please come forward?
All right. Come on down, you pages, my sunshines. Oh, my goodness. Okay, all you delegates, haven't they done a fantastic job?
Let's clap.
Come on. Oh, my God. Come on. Give it up. Give it up. Give it up. Give it up. Come on. They are fantastic.
They work really hard for us.
Yes, they work very, very hard, Madam Speaker. Okay, pages, I want y'all to have a nice weekend. We will not be in here tomorrow. And we're going to be 83 degrees tomorrow. So I want you to enjoy yourself and come back here ready and ready to come back on Monday, because we're going to be busy that whole week. So I hope you come back to visit us. Thank you and good night. Wonderful sunshines. Y'all can be dismissed.
Thank you so much. Thank you for being with us. We really appreciated you.
And Madam Speaker,
yes, recognizing the protocol.
We are doing such a good job. We have some wonderful delegates in here. I only have 12 that needs to still to come see this protocol chair. And y'all see what's in the lounge and things that I'm going to do for y'all. I want y'all to know, please still come see me, and your staff can come to what we got planned for you on Sunny Day. Okay. All ready? Are you ready? I'm still got hope for you. Thank you, Madam Speaker, very much.
You're welcome.
Madam Speaker.
Yes, recognizing the gentleman from Prince George's.
Vote change SB 465, yea to nay, please. Thank you.
Thank you. For the 12 people that are outstanding, can you please take the weekend to bring the money for Monday, please? Thank you so much. Quorum call, please.
Madam Speaker.
Anyone in the back? We're good. Thank you, Jeannie. Has everyone recorded their presence? The clerk will take the call. There being 117 members present, the House is still in session. Let's listen for the time.
Thank you, Madam Speaker.
Recognizing the majority leader.
I move that the House stands adjourned until Monday, April 6th at 3 o'clock p.m. Legislative date, March 19th.
3 p.m. Have a blessed weekend, everyone. Thank you for your hard work.